Fair housing protection of familial status. Not limited to tenants' children issue. The prospective tenant has completed a rental application for the apartment. The prospective tenant states in the rental application that his 12-year-old nephew will be living with him until his nephew completes middle school. There are no other children currently living in the apartment complex, and the landlord does not want to make an exception. Can the landlord refuse to rent the apartment to a tenant with a 12-year-old nephew? Answer: probably not. Under the fair housing laws, familial status extends to persons with legal custody of any child under the age of 18, or with written permission from the parent or legal custodian of a child under the age of 18. Therefore, the landlord can request from the prospective tenant written permission from the 12-year-old's parent or legal custodian. If the prospective tenant is unable to furnish such written permission, only then can the landlord refuse to rent the apartment to this prospective tenant. Arizona Realtor R. HOA cannot unreasonably restrict access to swimming pool. Issue: an HOA rule prohibits the use of the community swimming pool by anyone under 16 years of age unless accompanied by an adult. The tenant's 13-year-old son has been barred from the use of the swimming pool because of repeated violations of this HOA rule. Is this HOA rule enforceable under the Fair Housing Act? Answer: probably not. The Fair Housing Act, with some limited exceptions, e.g., housing for senior citizens, prohibits discrimination in housing against families with children under 18 years of age. In addition to prohibiting an outright denial of housing to families with children, the Fair Housing Act also prevents the imposition of special requirements on tenants with children. For example, tenants with children cannot be segregated to a separate area of a community, and unreasonable restrictions cannot be placed on access to recreational services in a community. The inability of a 13-year-old to use the swimming pool in the community without an adult is probably an unreasonable restriction. HUD provides guidelines for the use of equal housing. Logo facts. A licensee would like to advertise in a local newspaper. He is not sure what size logo to use for the equal housing symbol. Issue: are there size requirements for the equal housing symbol when advertising? Answer: HUD provides detailed information regarding how to comply with fair housing laws on its website. When advertising in print or any other media, HUD gives these guidelines, Paragraph 109-30, Faith Ease Guidelines and Practices. A. Use of equal housing opportunity logo type, statement, or slogan. All advertising of residential real estate for sale, rent, or financing should contain an equal housing opportunity logo type, as a means of educating the home-seeking public that the property is available to all persons regardless of race, color, religion, sex, handicap, familial status, or national origin. The choice of logo type will depend, in space advertising, on the size of the advertisement. Table I, see Appendix I, indicates suggested use of the logo type and size of logo type. Table II, see Appendix I, contains copies of the suggested equal housing opportunity logo type. Table I. A simple formula can guide the real estate advertiser in using the equal housing opportunity logo type. In all space advertising, advertising in regularly printed media such as newspapers or magazines, the following standards should be used. Size of advertisement. Size of logo type in inches, 1/2 page or larger. 2 1/8 page up to 1/2 page. 1 4-column inches to 1/8 page. 1/2 x 1/2. In space advertising which is less than 4-column inches, 1 column 4 inches long, or 2 columns 2 inches long, of a page in size, the equal housing opportunity slogan should be used. Such advertisements may be grouped with other advertisements under a caption which states that the housing is available to all without regard to race, color, religion, sex, handicap, familial status, or national origin. In any other advertisements, if other logo types are used in the advertisement, then the equal housing opportunity logo should be of a size at least equal to the largest of the other logo types. If no other logo types are used, then the type should be bold display face, which is clearly visible. Alternatively, when no other logotypes are used, 3 to 5% of an advertisement may be devoted to a statement of the Equal Housing Opportunity Policy. Table 2. Illustrations of logotype, statement, and slogan. Equal housing opportunity. Logotype. More information can be found at the HUD website. Equal housing logos can be found here to use on any advertising. Individual with AIDS may be entitled to a pet despite CC&R's issue. The CC&Rs in the community prohibit pets. An individual with AIDS is emotionally attached to a small dog. Is an individual with a disability, such as AIDS, entitled under the fair housing laws to a small dog despite the CC&R prohibition against pets? Answer. If the small dog is necessary for the individual with AIDS to have an equal opportunity to use and enjoy his home, the no pets provision of the CC&Rs could probably not be enforced. On the other hand, if the small dog is simply desirable by the individual with AIDS, there would be no violation of the fair housing laws if the no pets provision in the CC&Rs was enforced.